Right, I think we can start with our first session, legal transplants from antiquity into modern law. Our first speaker is Katarina Delja from the University of Belgrade, and she will speak about Lex Rhodia de iactu. Please, you can start.
Thank you so much. Hello, everybody. I'm pleased that I'm here, and I'm very happy that I'm able to participate in this event. So as you heard today, I will be speaking about Lex Rhodia de iactu, my paper that I titled that way. And Lex Rhodia de iactu is a Latin term that was used for a maritime law in a situation of a shipwreck. So this law first originated in Phoenicia. And Phoenicia was a very small civilization in terms of territory. They were located between the eastern shores of Mediterranean Sea and the mountains of today's Lebanon. But despite that, they were a very powerful civilization. And we can call them the great merchants of antiquity. They established trade in Central Asia and in Europe from the Baltic Seas to the Adriatic and Mediterranean Seas. And of course, as they had a good established maritime trade, they developed many maritime laws and maritime habits. Unfortunately, they weren't able to codify their maritime law because of the very turbulent history they had and the frequent wars that they suffered. The first codification of maritime law was created in the city of Rhodes in 8th century BC. And the city of Rhodes was one of the many Phoenician colonies. They also had good established maritime trade, so it was quite natural for them to make this first codification of maritime or admiralty law. And when this codification was created, now they had Rhodian sea laws that provided rules for carrying out trade in a very efficient manner all over the Mediterranean Sea. This codification also established some of the uniform standards for the treatment of the merchants that moved from port to port every day. And now also disputes arising at sea were being decided by the Rhodian law rather than in local courts. At the time, Greece was influencing the whole Mediterranean Sea, and many people took some fragments of this maritime law in their own legal systems. And especially due to the close cultural contact between Greece and Rome, Rome took fragments of this Rhodian sea law into their own legal code system. And Roman law, as we all know, was developing pretty autonomously, but due to the cultural closeness and due to some newly changed social situations, they had to apply some of the Greek maritime habits into their own legal system. And they just saw the practical need, and they decided to adopt this principle into their own legal code, because this was a very legal and a very fair regulation on the consequences of unpredictable sea dangers that threaten people's lives. And the first to see that this is a practical need and that it needs to be adopted into the Roman legal code was the two jurists, and especially those were Paul and Volusius Metianus. And from them, we only have two explicit fragments that mention explicitly the island of Rhodes. So the first one to actually introduce this principle in Roman legal system was the jurist Paul, and he explains it by saying, Lege Rhodia cavetur, ut si levande navis gratia iactus metium factus est, omnium contributiones sartiatur quod pro omnibus datum est, which translates to provided by the Rhodian law, where merchandise is thrown overboard for the purpose of lightening the ship, what has been lost for the benefits of all must be a contribution of all. And the second explicit mention of the island of Rhodes and their maritime law we have in some of the letters that Edumon of Nicomedia sent to the emperor when they had a major shipwreck that occurred, and he says that they suffered a shipwreck, and the emperor just answers by saying, do as it is according to the maritime law of the Rhodians. So that is the second explicit mention of the Rhodes Island in this Roman legal system. So the lawyer Paul, actually, I skipped. We can actually stop in this slide. It's not time for conclusion yet. The lawyer Paul actually decided to put this maritime law in the bilateral contract, which is based on a good faith. And as the Romans made use of this law, special tribunals were created, and they were taking care of the treatment of the merchants. Also, some exceptional courts were adopted and set up in the port towns, and they were deciding all of disputes that were arising at sea. And a uniform code based on the Rhodian law was recognized and essential to the efficient trade that could be in the Mediterranean Sea. And it was seen as a peaceful and profitable way to make trade work better in the Mediterranean Sea. And this law existed more than 1,000 years. So now we can skip to the conclusion. The uniform this is the uniform code, and this reception does not end in antiquity, which is very interesting. It only then proceeds to go into the medieval times in Byzantine. And in Byzantine, we have a Nomos Rhodionoticos, which is very similar and has many fragments of Rhodian sea law. And then also it develops, and now we can still cite some of the fragments into the modern law, which is very interesting. So the principle of compensation for individual things sacrificed in the interest of mutual benefit inspired many people and many nations, and they decided to adopt fragments of Rhodian law into their legal system, and also influenced later legal thinking. So as I said, we can still see some of the fragments of Rhodian law in modern codes, which is for me very, very interesting and inspiring. In Europe, for example, we can find many examples. We have in Czech law, in Turkish law, and even in the Serbian merchant shipping law, which is very, very interesting. And as I said, now it's time for the conclusion. And the aim of my paper was mostly to show that legal transplants existed in antiquity also, and that is not a new term. It's something that existed from a long time ago, and that this is a centuries-old legal principle that survived many centuries, so that we still use it. And something that is really interesting to me is that every civilization is different. Every civilization has its own uniqueness, but practical needs is what unites them, and practical needs make them come up with some brilliant solutions that we even still use today. So that was the aim of mostly, and I wanted to show that the survival of this legal institution indicates the toughness of overseas trade and the fact that some things don't change despite the modern technology and advanced modern times. Thank you so much.
Thank you very much. We will have another speaker, and later on there will be time for questions and discussion. And now I can announce another speaker. She is our regular guest here in Belgrade, and she came from Warsaw, Wiktoria Saracyn, from the Faculty of Law and Administration. And she will speak about Actio de pauperie in the modern code, legal transplant or lose inspiration. It is the title. Example of Alan Watson in his legal transplants, also Actio de pauperie, among other very interesting and picturesque, I would say, examples is also this. Please, you can.
Thank you very much. I think the mic is okay like that. Or should I? Okay. So I'm setting up my timer because, well, first I would like to start by not sugarcoating, but you were one of my inspirations when I was preparing this topic, because I think you know, but Professor Polojac is the author of a monograph to the pauperie, which I was also using extensively in my literature list. And the other thing I wanted to mention, which is kind of crucial, it is one of, I mean, it is mostly the biggest part of my PhD dissertation topic. Actio de pauperie is a huge part of it. And that's why, for the sake of this and for the sake of your patience as well, I had to choose one particular notion that I will speak about here today. And I will have to stick, which I normally don't do, I will have to stick to my notes, because otherwise I can discuss the topic for 5 hours straight. And I mean, you would get bored, I wouldn't. So I will just look at my notes from time to time. And this focus that I chose, because the scope of Actio de pauperie, of the regime of liability, its uniqueness is a very wide topic. So in order to broaden it and to talk about it as from the perspective of the legal transplant topic, I chose the comparison between the Roman regime with the Polish modern regime. Present in the Polish Civil Code, the actual Civil Code, which is from 1964 and still in force. And this focus will be to what extent, I mean, the question, I will put a question mark here, whether the Actio de pauperie can be considered to a certain extent a legal transplant into the modern Polish Civil Code, or it is only to be dogmatical foundation or a loose inspiration for the Polish legislator. And here I will just focus on the comparison of the regimes, the definition of the regimes of liability, not to like go in details and mention the particular premises of liability, which I will just notify. And so my thesis is that despite of what one can find in the Polish civil law doctrine, because what Professor mentioned in the introductory lecture was this resistance for the authority of Roman law, whether in Polish civil law doctrine, and quite an opposite is present. I mean, it's a scene of many scholars, modern scholars, that they say, okay, so as in Roman law, or already in Roman law, and then it turns out that it does not have much to do with Roman law. And this is the case that I will discuss in here. So my thesis is that despite of what one can find in this Polish civil law doctrine, their views, the Roman liability regime for the damage done by animals cannot be considered equal to the one applied by the Polish legislator in the Polish Civil Code. And so, as for you to have an idea of what I'm talking about, I will just briefly read the provision of the Polish Civil Code, mainly the Article 431, the liability for damage done by animals. Paragraph 1 is, anyone who owns or uses an animal is obliged to make good any damage caused by it, the animal, regardless for whether it was under his supervision or had strayed or run away. Him nor a person for whom he is responsible is at fault. And the second paragraph, even if a person who keeps or uses an animal is not responsible for it, in accordance with the provisions of the preceding paragraph, the aggrieved party may demand full or partial remedy for damage from, if it follows from the circumstances, and especially from the comparison of the financial condition of the aggrieved party or that of the other person, that the principles of community life so require. So at first glance, it is impossible to tell to what extent the wrong could have affected the Polish legislator's idea, but after a closer examination of the premises of liability in both of the aforementioned provisions, one could seek for reminiscence of Actio de pauperie in the Polish Civil Code, to a certain extent, of course, quite successfully. So the main aim of my paper is to demonstrate that the rules of liability for them done by animals in the Polish Civil Code can to have been dogmatically founded by the Roman legal thought, despite of the fact, we have to underline it, that the Polish liability regime is far from identical to the Roman one. And a footnote from me, there were some doctrinal call for changing the Polish regime so that it would be based on the risk. Based on risk, it would be in that case risk-based liability. But luckily enough, it did not happen. So it has remained this regime that we have it now, which is fault in supervision. We could sum up it like this, sum it up in this way. So it remained untouched like this since 1864, and actually, but the code is from 1964. So that was the Polish regime. And what about Roman regime? And now I'm just looking at my timer, not to make it excessive. So Actio de pauperie has its origin in the law of 12 tables, and we know it because it has been excessively described in the digest, book 9. So the book 9 is on the liability in general, but Actio de pauperie opens the whole book on liability. Maybe because the Justiniani compilers thought, since it is one of the first, chronologically speaking, basis of the liability, and it was still enforced even after the enactment of Lex Actilia, because Lex Actilia is about the liability with fault, and Actio de pauperie, there's no fault there present, so it was still enforced, and it was chronologically speaking the first one. Maybe that's the reason why it opens the book 9, but that's just one of the idea. Anyways, compilers put it at the beginning. Alpion's commentary to the edict. Alpion says, the fragment that is opening the book from the commentary to the edict says, if a four-footed animal is claimed to have committed pauperies, so the damage done by animal, an action from the law of 12 tables will be granted. This law wanted either to give away it what damaged, so the animal, that caused harm, or to pay the pecuniary value of the damage. And later on, there are fragments from the commentary to the edict where the jurist describes the premises of liability. And I put those premises of liability into three categories. So the first category is on the legal character of the damage. So the jurist describes the legal character of the damage. Then proper premises of liability. By proper, I mean the conditions that have to be fulfilled for the Actio de pauperie to be applicable, to be granted. And then the third category would be on the contribution to the damage. So whether the action will be granted if there is a contribution on the part of the harmed party, in the injured party, or some third party. That's the structure, but I won't be going into details. My main point is that since I will not be able, due to the time limit, to explain what does the Roman liability regime consist of, I will focus on explaining what it does not consist of in comparison to the Polish regime. And for sure, it does not consist of the presumption of fault in supervision. And why? And I will have to, I think, cut a little bit. I know it by now. Another footnote, and for you to have an idea in what situations the Actio de pauperie would be applicable. So the gloss, which is the gloss of Accursius, mentions three theoretical genres of damage done by animals or done with the involvement of animals, among which only one from these three genres, only there in this one case, Actio de pauperie would be granted. So the cases are the following. The first one, I will skip Latin to make it shorter. The gloss says, an animal caused damage acting contrary to its nature without any human fault. And in such case, the jurist, the glossator says that in such case, Actio de pauperie is applicable, basing on the normative basis the jurist says. The case B, the second case, an animal caused damage by human fault. And here, Actio de pauperie is not applicable, of course, because there was human fault. But Actio legis aquilae, so the Aquilian liability, is applicable, of course. Human fault, great, but it's not, legally speaking, theoretically speaking, damage done by an animal, but done by the animal's owner with the involvement of the animal. And the third case is an animal caused damage acting according to its wild nature, but without any human fault. And in such case, no action will be granted because for the deeds, for the actions of wild animals, we don't have any actions, we don't have any liability. We only have, I mean, there's a small exception on edictum de felis, but still I will leave it aside because it is very particular and special. In that case, some wild animals would be considered domestic because of placing them in the city, but just let's leave it now. It would only consider domestic animals. So if an animal acting according to the wild nature committed damage, there's no action. Without any human fault, there's no action. So since according to the normative basis and the premises of liability that I have mentioned, in order for the Actio de pauperie to be applicable, to be granted, an animal must act cum mota veritate, which is by the force of its wild drive, internal drive, and the other premise, the proper premise would be the action has to be contra naturam, so against the animal's nature. Regardless for the nature being understood as the nature of the particular animal, of the genre of animals that Actio actually suggests, that it would be like that, contra naturam sui generis. But regardless for that, that makes the whole action of the animal completely unpredictable. And why I mean, it sounds a little bit obvious, but it was not so for the modern jurists. Since if it is unpredictable, it cannot be stopped by the animal's owner at any time, and it cannot be foreseen by them. So that very fact actually leads to the conclusion that if this action of the animal does not fit within the scope of the owner's duty of custodia. Yeah, because he could not have prevented it at any point. And in other words, the liability from Actio de pauperie does not have anything in common with culpa in custodiendo, because it was not covered by the duty of custody. So if it was so, then that would mean that the law required from the man, the owner, something that could not be complied, something impossible. And impossible duties, I mean, the law is not meant to require impossible duties from the man. So jumping immediately to the conclusion, since I have 1 minute left, the Roman regime of liability for damage done by animals is extremely complex and elaborate. Without a shadow of doubt, it served as an inspiration and a dogmatical foundation for the shapes of liability present in many European codes, civil codes, Polish, of course, among them. But one cannot put an equal sign between the Roman law in this particular case and the Polish regime. It cannot be considered a legal transplant, since the Polish liability regime is based on the presumption of culpa in custodiendo, and the Roman system is completely autonomous and not technically defined by one proper term dividing this regime of liability among other ones. And it does not certainly include culpa in custodiendo. That's my final conclusion. Luckily, supporting the preliminary thesis that I put while starting this research. Thank you very much.
Thank you very much for both speakers, students. Before I open this discussion, I would just like to comment first first item about Lex Rhodia the Actio in the light of Alan Watson theory of transplants. I think it is not, he didn't treat it, he didn't use this example in his book, or he has no comments on it. On the other side, Actio, the pauperie is very, one of his favorite examples. So it is, it's really, because it is also in a way amusing, and he likes this kind of examples. Please be free to ask questions.
They say that the reason why okay. Okay. Do you hear me? Okay. They say the reason why Rome persisted for so long is because they were capable of copying their enemies and and mastering whatever they took from them. So, in any chance, can we say that they did that with legal items like law and transplants, from Phoenicians? So they, in chance, can we say that they invented legal transplants so they could adapt more faster and outsmart their enemies? I don't know if I formulated my questions good enough.
Is it question for Katarina or Wiktoria? I think
Yeah, well, I can answer. For the Lex Rhodia de Actu, that was a very practical need, and it was a very fair legal regulation. And maritime trade was very, very important in the antiquity. So if the Romans did not recognize and accept this regulation, probably no one would want to trade with them, and that would be a very big loss for the Roman Empire. So in a way, they were a very powerful empire. I can say, pretty much tried to accept as many principles as they could, but not to as just like they had to keep their own Roman law, but they had to accept something to live that long. So I hope I gave a part of the answer.
Thank you. That's the one to ask.
any other questions? Professor Bro?
Well, I have questions for both. Should I do both together? What do you prefer, or should I do one at a time? About the Lex Rhodia de Actu, I was very intrigued about the fact that you said that there would be modern transplant in Turkish law. Did you say that? This is really intriguing. So, and would that be within the civil code or outside of it?
Well, they accepted this law after their big revolutions they had, and it is a law outside the civil code. It just, as in our also system, we have our legal code, and the shipping merchant law is just a law by itself. It's not the part of the code.
Okay, thank you very much. Then I wonder whether you have come across transplants of the Lex Rhodia de Actu also outside of maritime transport. There was a big movement in Germany in the 18th century to accept that, for example, for burning. I mean, when houses burned, and more houses burned, they applied also the Lex Rhodia de Actio.
Well, the Lex Rhodia de Actio had a really big influence, and it seems that influenced everybody's legal thinking later, and everybody adopted the fragment. So in Germany, as you said, and I'm glad you said it, I didn't want to mention it, I didn't want to overlap the time limit we had, but they use it in a similar way, but not in the way that Lex Rhodia is firstly definitioned. And also Lex Rhodia, I just was doing the Europe. I didn't want to go overboard, but we have examples even in Latin America, in America also, which is really in Asia also, they had a big trade. So for me, it was really fascinating how the Lex Rhodia had a big impact on the later legal thinking. And I'm currently working on my papers that go outside of the Europe and explain how Lex Rhodia was adopted in other legal systems. Hope I answered.
Just to elaborate on that German law, I mean, my source, where I found it was in Glück. I don't know whether you consulted Glück, ausführliche Erläuterungen. Yeah, because he actually adds that as a comment to Digest 14.2, saying, well, this is not Roman, but this is nowadays law. Okay, so you've seen that. It's pretty interesting. About domestic animals and wild animals. So you said that an animal could eventually change its nature. Is that what you said? By arriving into a city? No, I misunderstood that.
No, but I'm very glad for that question. It's one of the points that I could not elaborate on. Well, no, the nature is one thing. It's a premise of liability for an animal to act contrary to its own nature. And the Actio de pauperie regards the domestic animals, first four-footed animals, quadrupeds, tetrapus, and then Actio utilis was granted for the two-footed animals. And then it just, evolution in time, so it covered all the domestic animals, regardless for them losing 1 foot and becoming free-footed. Just let's leave it aside. But the point is that an animal should act contrary to its own nature. While when we are thinking about the bestia, when we Romans, I say, are thinking about the bestia, so the wild animals, causing damage because of being wild, because of acting unpredictably, is in the nature of wild animal. If you think about it, it's wild, so it will just do harm by acting wild. But I mentioned this one exception, not to just simplify things too much. There was a dictum de fellis which did not change a nature of an animal, but since wild animals were needed at the city for, I don't know, for like
Venaciones.
Yeah, exactly. And entertainment purpose. Yeah, let's call it like this. So since they were needed, it would not be okay for the Romans, so that no one could bear responsibility for the possible harm that they did. And since they were not domestic, they were not covered by Actio de pauperie. So that's why this edictum. But in this edictum, it not covered all the wild animals that entered the city, but only those which had owners which were kept there for this entertainment purpose in the city. And so that if they did any harm, someone would bear the financial responsibility for this damage. So that's the point.
But would that move them into the category of domestic animals or domesticated animals?
No, still neither of these two, because it was absolutely it was not within the regime for liability from Actio de pauperie. It was like a separate normative basis only for this kind of animals. So we would not be moving them from one category to another, but just granting protection for the harmed party if the wild animal kept in the city committed any harm.
May I add something? Because this was a list of animals, it is not a numerus clausus, and then it is added and any other, it is started with dogs, boars, and lions, and others, and other dangerous animals. This word is used. So it is kind of a mixture. This dog was later included into Actio, but not at the beginning. Now it is also treated as a danger. So then in this case of, for example, dogs, Actio de pauperie could be used in the same time both actions, other Actio de pauperie or Actio de pauperie. Then the regime is different because one is nocturnal and another is not. And in one situation, Actio de pauperie, when dog beats you when you enter into because of his coma paperistate. Either, and in other, it should be on the road, on the public road. And so it is also different. For example, in case of dogs, I'm sorry.
No,
it's
very good.
It is important.
But in this case, it's because of moving the dog from the category to wild animal into domestic, but not in legal terms, just on the like normal life basis. This is the only like example of that.
But now it is also interesting question for modern codifications, because you said in Polish civil code, it is only, and in most of the codes, only you have only term animal and nothing else, no difference. I think in German civil, in BGB, you have division of useful animals and, let's say, luxurious animals. And in case of this first, then it is presumed liability, and in other it is strict liability. So it's better for the owner when you have this presumed liability principle than strict. And for example, in most of the codes, I think, and the same in our civil, in a law of obligations, there is no special regulation about animals. They are only treated as dangerous things, in the category of things, dangerous things. So I think it is really not very nice. I mean, not very modern principle. Although we had in Serbian civil code special regulation for damage caused by animals, and now we don't have this. We have only
but you're saying
dangerous things.
You're saying it's not very modern, whereas the Polish civil law doctrine wanted to switch recently, a couple of years ago, from the regulation on the animals to moving this liability to making out of this liability strict liability and treating animals like dangerous things. Luckily, it didn't happen because some other voices just appeared saying that it would not be like axiologically motivated. I mean, the dogmatical foundation is other, just like you're saying, but the funny thing is that it does not look very modern, while it was a new idea to like for change, delegate agenda. So this is actually quite another argument against changing that regime.
Yeah, right. Any
was the doctrine used for damage caused by animals maybe similar to what they did with slaves, because both were considering things to some extent? So
well, it is kind of similar because the liability from Actio de pauperie is also, like the professor mentioned, noxal liability. So you could either give away the animal that caused harm, or pay the pecuniary extent of the damage. The interesting thing is that there was the choice was the owner's. So you, as an injured party, could not say, okay, so I want you to pay me because the damage is worth more than the animal is worth. No, you could not, because the owner is choosing, right? So in some cases, I'm not saying it was a common phenomenon. I have no data on that. There is no data on that. But looking at it from the modern perspective, when we really want to make good the damage to the exact amount of the pecuniary worth of the damage, it was otherwise in Roman law, because if your cow committed some harm, you could give it away even if the harm was worth like 4 times the worth of your cow. So you could actually, it could be good for you. But otherwise, if the harm was really small and you did not have the money, you would have to give away the cow, even though the worth of the cow exceeded the worth of the damage. So that is quite tricky here. Well, why not? I mean, Roman law, as we repeated many times here today, and I think we'll still be repeating, serves in many cases as an example, but we should not, and this is a quite common phenomenon, we should not mix the actual term of legal transplant and something being actual legal transplant with just being an inspiration, because it's just natural, normal that we will be inspired somehow. We all learn Roman law, right? In each European university, you will just have a course in Roman law. So that's the point, and we have to know the previous tradition to be just capable of developing some better institutions, right? But in case of this, what I was talking about, it's actually quite interesting that the modern liability regime is much more simple than the Roman one was. So sometimes you can be inspired by something and actually simplify in order to simplify, not actually to elaborate. So that's a funny thing.
Any other questions? All right, I can just conclude that I, of course, agree that it is only in, I don't know, Zimmerman used it, that the roots of liability of Roman law, but it is really very different, and Romans have even 4 or 5 different actions in case of damage. Maybe only one I think we can see it made really impact, like a kind of not like transplant. It is case of case of injury to a free man. And in that case, this is a liberum corpus estimationem non recipit, and this rule, we can recognize that in case of material damage, you can ask for compensation for doctor, or how to say,
For the medical expenses.
The medical expenses, sorry. Also, you can recognize that, and there is one text in Gaius text belonging to this digest, book 9, first type. And so, okay, so, and also I would like to add something that Alan Watson has also original theory on the word pauperies. And this is also one of his original, which were also not over. It is mainly accepted, but our colleague Samir Alicic, who was writing on this damanum in the, like, he was just, he attacked his, one of this, his theory, so and also here kind of reminiscence of this. Okay, if there are no other questions, maybe then we can close this first session. Thank you very much. And